You drive for Amazon Flex out of Chicago's north side. 8 deliveries in today, your own car, your own route. Another driver runs a red light and you're in the ER. You report it to Amazon. The response is quick. Delivery drivers' workers' comp claims in Illinois don't apply to you. You're classified as an independent contractor. Workers' comp is for employees. What Amazon, FedEx, and other companies that use this argument are counting on is that you don't know what Illinois law actually says. The company's decision to classify you as a contractor does not determine whether you're legally entitled to workers' compensation coverage. Illinois courts and the Workers' Compensation Commission examine the economic reality of the working relationship. They look at how you actually do your job, not what your paperwork says. That test has been ruling in workers' favors with increasing frequency. This video covers what Amazon Flex, FedEx, contract drivers, UPS, and USPS workers are each entitled to under Illinois law, how the economic reality test works, and what happens when a court finds your employer misclassified you. There's one outcome in these cases that surprises almost every driver who hears it. The foundational question in every delivery driver workers' compensation case is this: does Illinois law see you as an employee? Not whether your company calls you one, not what your service agreement says, what the law actually determines when it examines the reality of how you work. Illinois workers' compensation coverage applies to employees under the Illinois Workers' Compensation Act. It does not automatically extend to true independent contractors. But here's where the system catches companies that rely on the contractor label as a shield. The classification in your paperwork is not the final word. When there's a dispute, Illinois courts and the Workers' Compensation Commission examine the economic reality of the working relationship. That analysis looks at who actually controls the work. Does the company set your hours or assign your routes? Does the company monitor your performance and have the power to deactivate you for failing to meet their standards? Is your work a regular and integral part of their core business operation? Are you restricted from doing similar work for other companies? The more control the company exercises over how you actually do your job, the more the relationship looks like employment under Illinois law, regardless of what your contract says. Amazon Flex. If you drive for Amazon Flex, Amazon classifies you as an independent contractor. You use your own vehicle, and you're operating as your own small business. But courts and labor agencies have been examining what Amazon Flex drivers actually experience on the job. Amazon controls the route through its app. They control the delivery window. Amazon monitors your GPS location in real time. Amazon rates your performance and can deactivate you for failing to meet metrics it sets and enforces unilaterally. That level of control is exactly what Illinois courts and the IWCC examine when assessing the economic reality of the working relationship. I've handled cases involving drivers who described every practical aspect of their work as something Amazon controlled, even though their tax form at the end of the year said that they were self-employed. The label and the day-to-day reality are not always the same thing, and Illinois law knows the difference. FedEx contract drivers. FedEx Ground built its delivery network for years around independent service providers, contractors who ran routes and employed their own drivers. Courts in multiple states examined that model and found that FedEx was exercising a level of control over those drivers that crossed the line from a contractor relationship to something closer to employment. Illinois courts looked at the same factors. If you drive a FedEx route in Illinois and the work requires FedEx branding, FedEx delivery standards, and adherence to FedEx timelines and performance requirements, the court may find that the economic reality of that relationship looks like employment, regardless of what the service provider agreement says. UPS and USPS. UPS drivers are employees of UPS. Many are Teamster union members. If you drive for UPS and get hurt on the job, you're entitled to workers' compensation benefits under Illinois law as an employee. There's no contractor misclassification argument to work through. The challenge in UPS injury cases is not coverage. It's making sure the claim is handled correctly and the injury is fully documented, because UPS, like any major employer, has a system for managing these claims that doesn't always serve the injured worker's interests. USPS is a different situation. United States Postal Service workers are federal employees. Federal employees injured on the job file under the Federal Employees Compensation Act, which is administered through the Department of Labor's Office of Workers' Compensation Programs. That is a separate system from Illinois Workers' Comp, with its own rules and processes. If you're a letter carrier or postal worker, you have coverage, but you're in a federal system, not a state system, and the differences matter. What happens when Illinois finds misclassification? If a court or the Illinois Workers' Compensation Commission determines that you were actually an employee despite your contract saying otherwise, the employer's workers' compensation insurance is required to cover your injury. The company cannot hide behind the contractor label once a legal determination goes against it. This is why I tell every driver in this situation not to wait. The company saying workers' comp doesn't apply is not a legal ruling. It's a position. And the time it takes to dispute that position, the clock on your claim is running. Every state workers' comp system has filing deadlines. In Illinois, the deadline is 3 years from the date of the accident, or 2 years from the date of last payment of compensation, whichever is later. Missing that window can permanently extinguish your right to benefits, regardless of how strong the underlying misclassification case might have been. If you're watching this for a partner or spouse who drives for Amazon, FedEx, or another delivery company and was told there's no workers' comp coverage, I want to address you directly. That answer from the company may reflect how their insurance policy is structured. It does not necessarily reflect the legal conclusions an Illinois court would reach after examining how your partner actually does the job. That legal analysis gives a pathway to coverage that the company's first phone call doesn't mention. A consultation with a workers' comp attorney costs nothing. One other thing worth knowing: if you do establish coverage, which this video shows is more likely than most drivers initially realize, one of the first and most important rights you'll want to understand is your right to choose your own treating physician. We cover exactly how that works under Illinois law in another video on this channel, including the nuances that most workers miss entirely. The bottom line here is this: if you drove for a delivery company in Illinois and were told workers' comp doesn't apply because of how the company classified you, that answer deserves to be challenged. Get the factual record of how you actually do your work in front of an attorney who handles misclassification cases. The hours you were available, the degree of control the app or the dispatcher exercised over your route and your day, how your performance was rated, and whether you could be removed for not meeting company set benchmarks. That is the factual record those legal factors run on. And in my experience, that record often tells a very different story than the contractor agreement does. If you've been told you're not covered, drop your situation in the comments or reach out through the contact information in the description. The consultation is free. Next, watch my video on how much an Illinois workers' comp case is worth. If you're working through a coverage dispute, understanding what the case could ultimately be valued at gives you context for everything that comes after. That video is on this channel. If you want to talk through your specific situation, contact information is in the description and the consultation is free. What company do you drive for? Drop it in the comments and I'll give you my read on the legal picture.